Welcome to It's No Accident, a podcast about the challenges of personal injury and wrongful death law in Florida, one of the nation's most complex legal environments.
You'll hear compelling stories about real cases from our law firm in Tallahassee that will help you better understand your rights and protect yourself from the negligence of others.
I'm Mark Nonni.
And I'm Jaeson Homola.
And this is
It's No Accident. All right, we talk a lot on this show about negligence. It's really the basis for what we do for a living is negligence, and we talk about how negligence is a choice, and what the elements of negligence are, and things like that. But one thing that we haven't really touched on, or not touched on a lot, is this idea of comparative negligence. And it comes up in our cases. I mean, it could come up in any case that we handle. But can you talk a little bit about what comparative negligence is?
Yeah, sure. And a lot of people, I think, it sounds maybe a little bit complicated, but it's a pretty basic concept. But I think a lot of the times when we get clients who come in, they're not really aware of it, and they don't understand how it could impact the value of their case and what's a fair settlement, right?
Right.
If the easiest way to think about it is, like if a case were to go to trial, and you're in front of the jury, when the jury's answering the questions and making their decision on all the questions they're getting asked on the jury form, there's almost, not always, but a lot of the times, they're going to have an opportunity to apportion the negligence or the fault between the plaintiff and the defendant, right? Like in an easy example where you have, we have one client, one plaintiff, and there's one defendant, the jury's going to have an option to split up the fault, and that's what comparative negligence is. Comparative negligence would be how much of the fault do they put on our client or put on the plaintiff, right? And the jury can split it up however they want it. It has to equal 100, so they could be 50-50, it could be 80% on the defendant, 20% on the plaintiff, vice versa, 60-40. They can split it up however they want, and it used to be, I guess until 2023, right, it was where if any amount that was attributed to the plaintiff. So if the jury decided that the plaintiff was 60% at fault, then the plaintiff would still win, but you just subtract 60% out of the amount of money that the jury came back with in their verdict. Right. And so if the jury, came back with $1 million verdict, but they said it was 60% the plaintiff's fault, when you take 60% out of it, so the verdict's actually or the judgment would be $400,000. Right. And so and that's what I mean, like by a second ago, where that, if you have a case where it looks like there's going to be a lot of fault put on your client, that can have a big impact on what a fair settlement would be, right? Right. In terms of that,
or whether you take the case in the first place.
Or whether you take the case or not, but like I said, it changed in 2023. It's 2023, right? And so you want to talk about what's it like now in terms of the comparative negligence? Yeah,
for sure. The tort reform statute that it's a lot of times called House Bill 837 that went through in 2023, and it was passed into law. It changed a lot of things, but one of the things that changed was the comparative negligence statute. And instead of a situation where if you're found 60% at fault, it takes 60% away from your verdict amount. Under the new law, if you are found to be anything over 50% at fault, then you get nothing. So if you're found to be 60% at fault, you don't get 40% of your damages, you get nothing.
You get zero.
So if you're more than half at fault for the injuries that you've sustained, then you get nothing.
Right.
So that was a huge change. It changed the way that we evaluate cases. It changed, and really in the sense it changed the way that we evaluate the cases when they come in, because there's close calls a lot of times. And some of those close calls, we would say, we're not going to be able to take your case. But some of the close calls, we would sign up and we would fight and try to make sure that our client got adequately compensated for their injuries. Under the old statute, you had the safety net, where even if your client was found to be 60, 70, 80% at fault, they were still going to get some of their compensation for some of their injuries based on the fault of the defendant.
Right.
Under the new statute, it's changed a lot because that safety net's now gone. And if we take a case to trial and the jury finds our client more than 50% at fault, there's nothing there.
You get nothing, right? And it like you said, it's definitely a safety net. And to me, it always seemed like the old way was fair, and the new system is kind of weird to me because it's basically, in terms of people being held accountable for their actions. That's kind of what you think of, in my mind at least, of what happens in court. When you have a lawsuit and you go to court, you're trying to hold people accountable.
Right.
And so, like in the extreme example where if the jury finds the plaintiff 51% at fault, then the plaintiff gets 0. So
Right.
basically it means the defendant was 49% at fault, but they're not being held accountable at all for their actions. They get off scot-free.
Right.
They're not having to pay anything, right?
Right.
Like, it doesn't seem, I don't know. To me, it just, the old system seemed more fair from that perspective. Like, why are we letting people off the hook? Just because the plaintiff was 51% at fault.
Well, and it's interesting too because if our client's found 30% at fault, the defendant still only has to pay 70%.
Right.
Why wouldn't it be a situation where if our client's found only 30% at fault, then they have to pay the full freight?
Exactly. Yeah, and you're right. It's a good point. It goes both ways, right?
Right. Right.
So yeah, no, it makes a big like you said though, an impact on taking a case, and really because unfortunately, I guess you could say, a lot of the times, and I'm not. There's plenty of good defense attorneys out there. I'm not saying that they're all bad, but they're just doing a job. And a lot of times, one of their main arguments, one of their main moves is blame the victim, right?
Right.
Try to blame the victim however you can, and they're good at it, and they can do a pretty good job of getting juries to put fault on plaintiffs even when you wouldn't think it, And I think every one of our clients who comes in, they, 9 times out of 10, even if they have some fault in the situation, they don't think that, or they don't feel that way, or they don't see that.
Right.
And so it can be difficult to explain to them, like, the defense attorneys are good, and they're gonna, do a good job arguing to blame the victim and get some fault put on you, most likely. Especially, like, for example, like a slip and fall and trip and fall case. Like, I know, I haven't done like a big study on all the data, but it seems to me like in every one of those cases that I've seen that's gone to trial, there's always at least some amount of percentage of fault that gets placed on a plaintiff for not watching where you're going or being clumsy or something like that, right?
Unless the defendant really pisses off the jury, there's probably going to be at least 1% that gets put on your client.
Right, exactly. And so now it's just makes it, the fact that 51% can get you nothing, just makes it a little bit. You gotta be more careful in terms of which cases you're taking, and then trying to explain that to a client. Sometimes, like, I can't take your case because of this is difficult. I will say at least it's better. Georgia, if it's 50-50, you get nothing. So at least in Florida now, if the jury says 50-50, you still get half.
Right.
In Florida, it has to be more than 50%.
Right.
So at 51%, you get nothing in terms of the plaintiff. In Georgia and some other states, if the jury says it's 50-50, you get 0.
Yeah, they want to split the baby.
Yeah,
I mean, it's
right.
and
That's even scarier.
Yeah, the juries are humans, just like everybody else, and sometimes they get tired and they get lazy and they compromise, and if they're going at it for a long period of time and the jury's fighting with one another as to what they're going to decide, a lot of times let's split the baby, and luckily in Florida, if they split the baby, you're still getting that 50%.
Right.
In Georgia, not so much.
No, for sure. And then, I guess really, while we're talking about this, I mean, it's not the law in Florida, or I think it is in some states, I can't remember which ones, but the other end of the spectrum, in terms of these kind of legal theories and the legal systems of the way it's worked over the years in different states, there are some states, I think, that still have just pure contributory negligence, right? Where if the plaintiff gets found even 1% at fault, you get nothing.
Which is just
even
crazy.
More crazy, right?
Yeah, it's
in terms
crazy.
of letting people off the hook, like I was saying before, right?
Right. And then, yes, some of the cases where comparative negligence comes up more than other cases are, obviously, you're not going to see a whole lot of comparative negligence argument in rear-end collisions.
Right.
Although I have, a lot of times it's interesting. You'll get a case in, and the driver that rear-ends our client will go up to our client's vehicle, say they're sorry, say it was their fault. It gets deeper into the case. We end up having to litigate the case. We get to the deposition of the person and they'll tell the cop that they were at fault. We get to the deposition of the person, and then out of nowhere they throw this curveball like, oh, well, your guy stopped suddenly and unexpectedly.
Right.
And it's funny because their language tracks the language of the statute, which is a defense in the case. So it's like, well, sounds like somebody got prepped by their attorney before the deposition to say what they needed to say to try to make a comparative negligence argument. Mm-hmm. But slip and fall cases, trip and fall cases, those are the cases where you're going to see comparative negligence arguments in pretty much every case. If you've got an intersection collision case, you're going to see the comparative negligence argument a lot, because a lot of times it's a he said, she said sort of situation as to who had the green light, who went first from the stop sign sort of thing. But in the slip and fall, trip and fall cases, some of the things that get argued to try to put comparative negligence on our client are the shoes that they were wearing. the fact that they weren't looking where they were going.
Right.
You know, they should have seen the water on the floor. What are some of the ways that we combat those arguments?
Sure, I mean, part of it is, I guess, really case selection. Kind of like we said earlier, like, there's some trip and fall and slip and fall cases that, I think that we just wouldn't take that since they changed the law. You know
Right.
what I mean? Part of it is just trying to establish, trying to predict the arguments that are going to be made and try to go ahead and knock them out on the front end, right? Like in terms of, like you said, shoes. A lot of times they're going to hyper focus on what kind of shoes our clients were wearing, and so usually we'll have the client, we'll explain the importance of the shoes to the clients, tell them to stop wearing those shoes. Have them. A lot of times I'll have them bring them in here, and we'll take them into evidence and store them until the end of the case. If not that, at least have them put them somewhere safe in their house and not wear them anymore, and take photos of them.
Right.
To show that in those kind of situations we're looking for, some type of tennis shoes or athletic shoes, ideally, in terms of what gives us the best argument and
Sure.
us the best position is something with a rubber sole that has a lot of tread on it still.
Right.
Not like if you're in some leather sole loafers that are already kind of slippery shoes, like that's going to give the defense a better argument.
Yeah,
Right?
and it's really about the tread on the bottom of the
Right.
shoes, because even if you're in sandals or slides or something like that, as long as there's some tread on the bottom of the shoe that can give you some traction if you step in something wet, there's not a whole lot of argument that they've got. This wasn't a case that we took to trial, but there was a local plaintiff's attorney that took a case to trial as a slip and fall case, and I forget who the defendant was. It was one of the large retailers, and the defendant hyper-focused on the shoes that the plaintiff was wearing, because the plaintiff was wearing sandals at the time. And you could kind of tell that they really didn't have any other argument, so that was what they had. They were going to go with it. And it's funny, we talked a little bit about making the jury mad and not getting any sort of comparative negligence. I think the plaintiff's attorney made the argument in closing that the defendant has wanted to focus on the fact that the plaintiff was wearing sandals at the time of the fall, and has seemed to forget that we live in Florida and sandals could be argued to be the state shoe of Florida. And the jury, I guess, latched onto that because they found the retailer 100% at fault for the fall and didn't put any comparative negligence on the plaintiff.
That's impressive, right? That's pretty rare. That's pretty impressive to get something like that. But it's, it makes sense. I mean, you would, expect that a lot of people on that jury probably think themselves, I wear sandals, I wear flip-flops all the freaking time. Does that mean just because, like, if you're a business and you have something dangerous and I get hurt because of it, like, you get off the hook just because I wore flip-flops, like, 90% of other Floridians, especially in the summer?
Right. And one of the other ones that we'll tend to see is you weren't watching where you were going.
Right.
And when you first hear that argument, it sounds like a good argument.
Right.
It sounds like a good argument, but when you actually start to think about it, you're like, wait a second, when I'm walking, I'm not looking at the ground directly in front of me, especially if you are in a retail store. Mm-hmm. And one of the things that we've seen, and we've actually gotten these documents in the past for some of these retail stores, is that there is a concerted effort by the food manufacturers, like in a grocery store, or in a retail store like the clothing manufacturers, to get their product in the spot that consumers will see it the best. That's why you see the more expensive cereals on the higher levels, because it's at eye level, and you see the, I guess what you'd say, like the knockoff cereals on the cereal aisle on the lower levels, because wouldn't you think people are looking at eye level at the products on the shelf, they're not looking at their feet.
Right.
So you get those documents from the store and you're like, well, you're starting to contradict yourself here. You are, you're saying that you want people to be looking at eye level for the products, and they've got these bright products and trying to draw people's attention to the colorful cereal box, but at the same time, they're supposed to be looking down at the ground so they can see the water that's on the floor that you failed to clean up for the last hour.
Exactly.
So
yeah, no, it doesn't make any sense. It's like if you're on a store, your goal is to get people to buy stuff, and so you know, from that perspective, you don't want people walking around your store looking at their feet the whole time.
Right.
If you're trying to get them to buy stuff. You
Yeah,
know? And
it's not good for business.
No, and it's like you're saying, they put a lot of money into, the product placement on the shelving and the merchandising of it all. And also, I mean, this is not necessarily the store, but just the brands themselves, like in the grocery store or something, they're putting a lot of money into having that packaging catch your eye, right?
They put more money into their advertising. That's why their cereal costs more than the one that's on the bottom shelf.
And so between the two of them, everybody's trying to focus on getting your eyes on the shelves, whether it's food or clothing or whatever, And so, like you said, it just doesn't really make any sense to then blame the person for looking at the spot where you spent a lot of money to try to get them to look. Right. And it's also kind of, in my mind, the whole you weren't looking where you're going is kind of, it's not a catch-22, but it's just weird because it's like, well, yeah, like if it's like if you were to have seen the puddle or whatever it caused you to fall, then you wouldn't have fallen.
Right.
And
right.
But then you're gonna blame the person for not seeing it. Again, I guess it goes back to like you're saying, because you're looking where you're supposed to be looking, which is on the shelving. But,
right.
It just doesn't. I don't know.
Yeah, and it's. I mean, when I first started practicing law and I was handling those types of cases, I would hear that argument and I'd be like, huh, that actually sounds pretty, that sounds like a decent argument. And I'd kind of look at my client and be like, why weren't you watching where you were going? But then you started to think about it, you started practicing a little bit longer, and you start to see more and more of these cases. And it's not just that one person that's not necessarily looking at the ground directly in front of them. And you start to, in your everyday life yourself, try to analyze what you're doing in your everyday life. And I'm looking at the shelving, and I'm not looking at the floor directly in front of me. And there's been time. There was actually a time here in Tallahassee where I was walking into a store, and there was literally like shelving that hadn't been put up yet. And I was talking to the person that was with me, and I was looking at something else. And I literally, this thing was clear as day as you were walking in, and I tripped over it and almost fell and busted my butt. But it just goes to show that it doesn't matter how out in the open something is. If you're distracted by something that's on the shelf or somebody that you're with, it's always possible not to see it.
Right. That's right.
This conversation continues and much more on the next episode of It's No Accident.